Welcome back to the Salvation Army Red Shield Symposium. If you've made it this far, you might as well stay for the next hour because we'll be doing a review of ethical considerations in estate and charitable planning, or as I like to say sometimes, good gifts gone bad. And I take a case study approach, so I think you'll find some of these examples interesting and hopefully will help keep you awake for the remainder of the day. I also am a big movie fan, so I have some movie references here. In terms of Red Shield Symposium Confidential, love the movie L.A. Confidential. If you've not seen it, highly recommended. And of course, I'm a science fiction fan, so anything X-Files I get a kick out of. So these will be confessions from my ethical X-Files or case studies that I've heard or read about from others. So in opening the Ethical X-Files, here's a picture of a fundraiser for a charitable organization. And sometimes the question might be, is this fundraiser very happy because they've received this generous gift from a benefactor, or is this a fund advisor, an investment broker, happy because they're getting a bag full of a commission or kickback from securing a charitable gift annuity contribution to a charity, which is an ethical violation and bad practice that did actually occur in the charitable sector, not with the Salvation Army, but other charities. So in any event, these are some of the issues we'll be talking about. We will provide an overview of ethics, of course, and then we're going to apply the model standards of practice for the charitable gift planner, and I'll talk more about that in a minute. With two qualifications, of course, that gift planning requires teamwork, both those of us who work in the nonprofit sector, as well as you, the advisors to your clients. And ethical issues, of course, are sometimes easier to identify than necessarily to always resolve in the best way possible. Of course, there are many definitions of ethics. One is the rules or standards governing conduct of the members of a profession. And as it applies to you and us in the Army as professionals, that might be one way for us to look at ethics. Of course, the role of ethics in charitable planning is self-evident. You know, we serve a wonderful mission here in the Salvation Army of public service. Our stewardship with donors, very important. The value of our good reputation with all of our constituencies, very, very important. But there are a lot of recent issues involving good gifts gone bad, problems with all kinds of gifts such as non-cash gifts, easements, donor advised funds, supporting organizations, and the like. And we're going to review a lot of those today. Ethical frameworks are plentiful. Of course, we love the golden rule, taking into account and reflect a concern for the interests and well-being of all stakeholders. There's the Kantian imperative, always reflect the precedence of ethical values and principles over non-ethical values. Utilitarianism, violate an ethical principle only when truly necessary to advance another ethical principle. Different ways of looking at ethical frameworks. One framework I tend to like is one promoted by the Josephson Institute. Josephson himself, as it turns out, is a lawyer. And he provides a recommendation that you have a stakeholder analysis. That is, who are our stakeholders? Our donors, the charities, our organizations, the IRS, taxpayers. Because, by the way, taxpayers are giving us these wonderful tax benefits of federal tax exemption, state tax exemption, for donors, avoidance of income tax liability. But so there's an analysis of all the roles and responsibilities of stakeholders, as well as clarity around your principles. What are the principles that govern your ethical decision making? Of course, under this kind of approach of the Josephson Institute, there are three stages of concern. Clearly illegal matters that, of course, you avoid. We're going to talk about some of those today. Clearly unethical. We'll talk about some of those as well. But more particularly are these ethical dilemmas, areas of dilemma, where it's difficult to discern what the right path is. So in the area of dilemmas, then 5 steps to principled reasoning. And again, for most of us who've been to law school, to a professional school or training of any sort, we understand these perhaps principles of good reasoning. Clarify the facts, not just clarify the facts, but clarify the law. In my work, finding the truth behind the facts sometimes takes a lot of effort. And then evaluate the situation in light of the applicable facts and the applicable law that may apply. Make a decision, implement your decision, then monitor and modify for the future as you evaluate the results of your decision making. So a good way to go about ethical reasoning. Lots of wonderful sources of information on ethics in the nonprofit sector, ethics involving philanthropy from a group called the Independent Sector that we'll talk about later. Ethics Resource Center. I've already mentioned the Josephson Institute on Ethics, the IU Lilly School of Philanthropy. I love the Greenleaf Center for Servant Leadership, wonderful resources there for board training. The National Charity Information Bureau, John Templeton Foundation, and so forth. Wonderful sources. Of course, we have codes of conduct. You know, in the for-profit sector, the American Bar Association, the Model Standards of Practice for Lawyers, the Rules of Professional Conduct, American Institute of CPAs, and so forth. All professional advisor groups have their own unique codes of ethics. As well as in the nonprofit sector, we have a document called the Donor Bill of Rights, which is an articulation of 10 rights that donors should expect in terms of their relationship with charities. In addition, the Association of Fundraising Professionals, Independent Sector, Healthcare Philanthropy, Council on Foundations, all have ethical statements or standards that they encourage their members and the practitioners to abide by. As I've looked over the years at various codes of conduct for both the for-profit and nonprofit sector, I identify certainly central themes of these codes. One theme is the one of protecting confidentiality. As professional advisors, you protect the confidentiality of your clients and their interests. We also want to, and we in the Salvation Army want to protect the confidentiality of our donors and our donor records. In addition, we want to avoid conflicts of interest. And, you know, we often think of conflicts of interest as extracting personal financial benefit out of one's transactions, let's say as a member of a board of directors. And we're going to talk about a violation of conflicts of interest in the next hour as we talk about specific examples. But there's also another kind of conflict of interest. And again, conflict of interest is derivative of, let's say, if you're a board member, what's called the duty of loyalty. Now, for many of you as professional advisors and communities, you're on boards of directors, you're counsel to nonprofit boards of directors. And quite often, there is a conflict where a director tries to leverage personal financial benefit out of a charity. But another kind of conflict and a violation of duty of loyalty is using confidential information gleaned by the nonprofit for the benefit of another nonprofit. So let me give you an example. Mary is on multiple boards in town. She's on every board in town. And she's on board A on Monday night in a board meeting, and they're talking about gifts, and somebody in the boardroom says, well, what about Bob? Somebody's got to talk about Bob. He's loaded, and he has no kids, and he's probably looking to leave a legacy. So somebody needs to talk to Bob about a gift. Then Mary is at board meeting B on Wednesday night. And what are they doing? Like all nonprofits, they're always worried about more money, fundraising revenue. And so Mary, without thinking, speaks up and says, well, what about Bob? I hear he's loaded, and he might be looking to leave a legacy. Now, Mary has unwittingly, or perhaps intentionally, revealed confidential information she learned in board meeting A to another nonprofit in board meeting B. That's a conflict of interest. That's a violation of her duty of loyalty owed to board A. In addition, of course, we want to assure competence. And you as professional advisors, that's why you're attending continuing education like this, to assure continued competence. We in the nonprofit sector want to assure competence as well. And furthermore, for example, we and all the plan-giving staff I represent in the Army, we know our boundaries. We know we are not the advisors to your clients. We are there to be of help to you, to give accurate and good information to donors everywhere. But we always do that with encouragement that they seek their own independent counsel, and that we are cheerleaders for the estate planning profession, lawyers, accountants, financial advisors of all types. We encourage our donors to seek independent counsel because we are not their advisors. But we are here to provide helpful, accurate, and hopefully good information to you and your clients and other donors to make wise decisions. We want to comply with all legal and ethical principles. We'll talk about examples of that, as well as fair and appropriate compensation and not kickbacks or other kinds of forms of remuneration that violate ethical practices. So those are key themes. Now what we'd like to do is, in sharing my confessions from my Ethical X-Files, I'd like to reference the Model Standards of Practice of the Charitable Gift Planner. You should have a separate one-page handout of these model standards. This is a set of standards promulgated by the National Association of Charitable Gift Planners, as well as the American Council on Gift Annuities. 10 principles or model standards of practice And it applies equally to those of us in the nonprofit professions as fundraisers or other nonprofit professionals, as well as to you, lawyers, accountants, financial advisors, and your for-profit work. And so these 10 principles provide a good set of guideposts for our conversation. So I'm going to go through all 10 principles. I'm not going to read them verbatim. I'm going to refer to them and give examples of how they apply in the real world in terms of ethics and gift and estate planning. So let me share my confessions. And I'd like to do so also with a few movie references. So the first model standard is assuring the primacy of the philanthropic motivation, making sure that the motive to make a gift is first and foremost the primary factor in the decision making. There's a Spike Lee movie called Do the Right Thing, where actually doing the right thing is rather difficult in that movie for a lot of the actors, good and bad. But it is an interesting movie that you may want to consider. When it comes to primacy of philanthropic motive, it's important for individuals to back up and understand what a charitable gift is. And there is, in fact, the U.S. versus American Bar Endowment Supreme Court case that defines what a gift is for purposes of accruing tax benefits. So we're talking about what are the requirements of a gift to accrue the federal tax benefits. Well, there is the subject of intent. That is, there must be obviously the donor's capacity to be able to decide, and quite often in this profession, we often deal with donors who have either intermittent incapacity or permanent incapacity, and we have to be mindful of that, and we have training around that, and we do express great concern to family or their advisors when we think there may be a matter of incapacity. So there's an intention to make a gift, very important. Plus there's an objective test to a gift. That is an actual transfer, irrevocable transfer from the donor to the charitable organization. And by the way, it has to be a qualified charitable organization. And now, not all gifts that qualify for tax benefits have to be made to organizations that are technically qualified as 501c3 organizations. 501c3 is the tax code of organizations that do qualify for charitable deductions. There are a few exceptions. There are some 501c organizations that do allow for charitable deductions for gifts, cemetery companies, some veterans organizations, and the like. But those are few and far between exceptions. Generally, a charity has to be a 501c3 to qualify for a charitable organization or for a charitable contribution deduction or benefit. But donors can make gifts and money used for other charitable purposes by other kinds of intermediaries, and as long as what's called best practice and responsibility of documenting the gift, can a deduction be had. And furthermore, for the tax deduction, there can be no return benefit. So a donor may get return benefit or a quid pro quo, but that will be disqualified from the valuation of their charitable deduction. No deduction for the value of any return benefit or quid pro quo. So there are some examples of types of transfers that can be highly valuable for a charity, but do not qualify for any tax benefits. So there's, for example, no deduction for a gift of time and services. So you lawyers, accountants, financial advisors who generously donate your time as a volunteer cannot claim a deduction for the value of your time. There's no deduction for the loan of property. It's only property that's irrevocably given. And again, no matter how valuable that loan property is, it could be a loan of office space, a loan of equipment, any sort of loan, no charitable tax benefit. No deduction for gifts of partial interest in property with the specific exceptions, and I've already noted many of the exceptions. These split interest gifts like charitable remainder trust, charitable lead trust, conservation easement, the gift annuity, those are qualified partial interest gifts. But otherwise, that's it. No other allowed. We've talked about the reduction rules in the prior hour. And again, IRS publication 526 entitled Charitable Contributions, very helpful publication that describes all these rules. Also, when gifts are made that assist others, there must be what's called a charitable class. That is a class of potential recipients of a gift, like say a scholarship fund or a disaster relief fund or any kind of monies that are spent to help other people, the class of potential recipients must be sufficiently broad or indefinite to avoid pre-identification or selection. So the point is that a donor cannot earmark gifts for specific people. And rather, the intermediary charity has to have complete discretion and control over it, and furthermore, no personal benefit to the donor or their family. Donors cannot attach strings to a gift, that if the charity doesn't comply with those strings, that it would pull the gift back into the hands of the donor. So things like right of revert or right of first refusal would disqualify the gift for federal tax benefits. When we talk about strings attached, there is the issue of donor restrictions. I like to say that quite often when I worked with the World War II generation, early in my career, I felt like their mentality of giving was, I love you, I trust you, here's your gift. Whereas now with the baby boomer generation, it's, I love you, but I'm not sure I trust you. So donor restrictions have become a bit of a big deal in the charitable sector. And so under both trust law and nonprofit corporation law, these restrictions are deemed as important and must be not disallowing use of the money for charitable purpose, but if they trigger a return of the money back to the donor, it will disqualify the charitable deduction. The flip side of this is whenever donors do restrict gifts or express their intent, it is very important for charities to seriously protect donor intent. And the Philanthropy Roundtable provides a wonderful resource on some of the rules and laws and cases involving adherence to donor intent. We're going to talk about a few examples here in the next few minutes. Restrictions can be modified. Quite often changes are necessary because the gift has become, the purposes or restrictions have become impossible, impractical, or illegal. Under common law from the trust code, we have the doctrines of cypre, which applied when the purpose became problematic, either impossible, impractical, or illegal. An equitable deviation is a doctrine used when the purpose is maybe acceptable, but something about the mechanics make it impossible, impractical, or illegal. So equitable deviation is applied to mechanics, cypre to purpose. Let me give you a couple examples. I worked on a scholarship fund where the donor had indicated the gift was a scholarship at a particular university for young women studying to be secretaries. Well, that university didn't have secretarial science anymore, so that purpose was impossible. So we followed the provisions of the Uniform Prudent Management of Institutional Funds Act to make essentially a cypre change to purpose. And with a blessing of the Attorney General and approval by a local judge, we had the purpose changed to young women with a business major. Equitable deviation examples, a donor set up a scholarship fund indicating that a $100 specific award would be made every year. Well, that was originally made in the 1930s when $100 meant a lot. Fast forward to today, $100 doesn't do much. Meanwhile, the value of the fund skyrocketed. So that's where the mechanics became impractical. Yes, we could do $100 awards, but that's an impractical dollar amount given the cost of education. So again, we got blessing of the Attorney General, approval by a local judge, and we did an equitable deviation to change that to allow for a spending rate applied to the fund to generate a larger dollar amount that would pay meaningful scholarship awards. These kind of rules for the procedure for changing funds comes from your state's Uniform Prudent Management of Institutional Funds Act. 49 of the 50 states have passed this law. The one state that has not is Pennsylvania. They have other laws that kind of apply to this. And so here are the definition of funds under UPMIFA. I'm not going to go into detail. The definition of a gift instrument and record under UPMIFA. But here we see that there are 3 or 4 procedures outlined in UPMIFA for making changes to gift restrictions. The first one is, with the consent of the donor, a change can be made. So the donor and the charity essentially amend the agreement and make a change. Another portion of UPMIFA is making a change to the management or investment of the fund. And this is the equitable deviation doctrine in play. When something about the mechanics of the management or investment of the fund become impossible, impractical, and so forth, then the procedure can be followed. And again, the procedure is local court approval with notice to the Attorney General. And then the third is Cypre, when the charitable purpose of the fund becomes, again, unlawful, impractical, impossible, wasteful. There again, the procedure is the same. Notice and approval of the Attorney General, and then final blessing with a court order from the local judge. And then in most states, there's a provision for funds that are over a certain number of years, usually 20, and under a certain dollar amount. In some cases, $250,000, sometimes a less dollar amount, whereby with simply notice to the Attorney General, no court order necessary, you can make the change in cases where it's impossible, impractical, and so forth. So simple notice to the Attorney General is all that's necessary in those cases. So let's go through a few examples. We have the St. Mary's Medical Center case in Indiana, where we had a trust set up for the establishment of a chapel. The hospital where that chapel was set up decided to take down the chapel. Survivors of the original donor brought a legal action saying that that's a violation of donor intent for the gift for the chapel. The local court agreed with the hospital, finding that the hospital could take down the chapel because the hospital needed the space. It was appealed in Indiana, and we had a reported case that basically said that this was not a gift in trust, therefore Cypre under common law trust doctrine did not apply. So the court kind of used a contract analysis and fashioned this substantial compliance rule that basically the court said, as long as the charity has substantially complied with the terms of the original gift, then a change is possible. And so it's kind of a new doctrine of substantial compliance. And again, a lot of these cases are state law specific. Anyway, another case study is The Art of the Steal. And this is an actual movie. You can go to YouTube, Google in Art of the Steal. Now there's a mystery movie, Art of the Steal, but this is the documentary Art of the Steal, where a donor had stipulated that when he died, he had the world's most valuable art collection, Renoir, Picasso, and others. And this is one of the paintings in the collection. And he stipulated the paintings remain hanging as they did. Now, over time, this became problematic because the museum was in Marion, Pennsylvania, lots of administrative problems, and they ended up bringing an action in court, and equitable deviation was applied by the judge to move the paintings to the Philadelphia Art Museum. And if you look at the record of what the donor wanted, the Philadelphia Art Museum was the last place he might have wanted it to end up, but it's a famous case involving equitable deviation. We have a similar case with the O'Keeffe collection to Fisk University, where Fisk and the Walton family had agreed on a deal when Fisk needed some revenue, and they were going to share the art collection, which had been donated to Fisk. But folks complained. The Attorney General initially intervened and decided against it, but the court later approved and overruled the Attorney General and allowed the sharing agreement between Fisk University and the Walton family. We have the Marin County case involving a fund that was established, the Buck Trust case, that for the benefit of the citizens of Marin County on the north side of San Francisco, a very wealthy county. It was a fund at the San Francisco Community Foundation, and they brought an action in court to amend the trust to allow grant making outside of Marin County. When they brought the legal action, the judge actually decided that it did not need to be amended to help others outside Marin. There was plenty of needs within Marin, and the judge was rather activist and actually ruled on which charities might be benefited by it. So be careful what you ask for. You may not get the intended change you want. Going to the dogs, Leona Helmsley had made a trust, set up a trust. She had a large trust, $5 to $8 billion in a charitable trust. She, on her deathbed, indicated a mission statement that all of that money was to be used for the care of dogs and not for medical or other health-related causes that were originally in the trust. When she died, the trustees brought the action in court to decide whether the mission statement actually amended the trust. The judge decided it did not, but it's good to get things in writing well before the deathbed situation, obviously. We have another case study, the music lesson out of two donors, where Garth Brooks had what he thought was a gift agreement with a hospital naming opportunity for his mom. they did not do it even after payment of a pledge of $500,000. He actually sued and won. Now imagine a jury trial listening to this, and they awarded $1 million, $500,000 of it, which was punitive damages on the hospital for not fulfilling the intent of the donor pursuant to the agreement. In Vanderbilt, we had Confederate Memorial Hall. Vanderbilt decided they wanted to take the name off this building, and the Daughters of the Confederacy decided they would not abide by that, brought a lawsuit and enjoined Vanderbilt from taking the name off. The court agreed and said Vanderbilt could take the name off if they returned the value of the original gift plus interest, which calculated at the time of this ruling to be about $700,000. Ultimately, Vanderbilt did pay that amount to take the name off the building. So the court looked at it from very much a contract law requirement. The role of stewardship, a very big deal. We have in Ohio Michael Moritz, a prominent lawyer who donated a significant sum to Ohio State. They renamed the law school after him. He passed away. The surviving family decided to find out how the fund was being managed. They were distressed to learn that there was a significant decline in the value of the fund, and they were very dissatisfied with the fees charged to Ohio State for the fund. They appealed, or they hired law firm and learned that typically surviving family do not have standing to bring a suit or allege problems in this regard, but rather the remedy is to appeal to the Attorney General to seek a resolution of the matter. And that's the usual protocol in most states. A donor may have standing himself or herself, but otherwise, outside of the donor, it's the Attorney General that has the standing to bring charges or seek a resolution if charity is deemed to be dishonoring donor intent or doing something else inappropriate. The Attorney General of Ohio did not choose to intervene here. The family did recruit a legislator in Ohio to try to amend the Memphis statute to actually broaden standing. But that proposed legislation in Ohio did not pass. We have the case of Avery Fisher Hall in New York. Avery Fisher gave $10.5 million to name this beautiful hall. Here's a picture of it. And then some years later, David Geffen, the Hollywood producer, said, hey, I'll give you $100 million if you take Fisher's name off, put my name on the building. And they apparently gave $15 million, according to press releases or press coverage, to the Fisher family. And they took the gift, took Fisher's name off, and now it's Geffen Hall. We have a similar naming issue with regard to David Koch Theater in the Lincoln Center. He gave $100 million, but added in, you don't have to have my name here in perpetuity. You can take it off after 50 years. I actually worked with a donor from New York City who was so aggrieved by this Geffen case in Avery Fisher Hall that he wanted the board of directors of the charity he was making a gift to that qualified for naming of a building to have a gift agreement that says that his name would be on that building in perpetuity. So many charities that do naming rights for gifts have naming policies to govern these kinds of situations. And so naming policy is a very important procedure. There's the issue of tainted gifts, where donors did not obtain the money they have by illegal activity, but by activity that might be called unethical or inappropriate. You know, Mother Teresa, for example, took some heat for accepting gifts from Haitian dictator Duvalier and from Charles Keating, the jump bong king. Some of the thought process is, well, as long as it's not illegally obtained money, if somebody is not in, say, the public's favor and wants to, say, redeem themselves in some way by supporting charitable causes, so be it. But the former head of the Lilly School, fundraising school, used to say an adage that the only problem with tainted money is there's taint enough of it. Guilt can sometimes play a significant factor in philanthropy sometimes too. We have the Ken Lay Fund at the University of Missouri that sat unused, the chair, for a number of years as well. Refund was refused to Ken Lay to pay bills. He had asked for a refund of his gift. Of course, once you claim tax benefits, you cannot get a refund of your gift unless you file an amended return to disclaim all those tax benefits retroactively. We have the case of Mosley in California, where a donor-advised fund money, contributions made to a foundation, and the DAF made grants to the donor's children's private school to pay for their tuition. And here it was a criminal matter that led to a criminal case involving penalties to the donor, and ultimately the charity was audited, the National Heritage Foundation, which no longer exists. Donor advised funds, of course, have been a focus of IRS review to assure that there's no self-dealing or inappropriate use. And so I showed you in the earlier presentation this law about donor advised funds. I highlighted that Code Section 4967 stipulates that no more than an incidental financial benefit may be received from a DAF, with those exceptions we talked about. The second ethical standard is the explanation of tax benefits or tax implications. And as we all know, sometimes the smallest of things can loom large later as the biggest of problems. And the movie I like to reference is Crouching Tiger, Hidden Dragon, if you've ever seen that movie. And kind of the biggest, baddest kung fu fighter in that movie was this very small, diminutive Oriental woman who turned out to be just this heck of a good kung fu fighter. So you never know where a big problem will loom. And that relates a bit to the software matters. That is, we in the Salvation Army do have the advanced software, but on every page or most of the pages of our software, there is a disclaimer that donors need to share these illustrations, factual illustrations, with their financial advisors, their lawyers. We are not providing tax or accounting advice. And furthermore, we can only show the results of the assumptions that the donor provides us. I had an instance early in my career where a donor indicated a mathematical error in the software results. This was back in the day, and as it turns out, this donor was right. Our software manufacturer had entered some of the tax tables incorrectly. Now, this was over 20 years ago, and now the software has evolved and is quite sophisticated, but it does highlight the importance that we do encourage our donors to always seek their independent counsel. I've already talked about the prearranged sale rule, so I'm going to skip over that. The flip trust, I highlighted in my other hour presentation, but there's a case where in the flip trust, the income is not expected to begin until the property donated to the trust is sold and you've got cash to fund the income. And in this case, the donor did not, or claims they did not understand that, and they expected the income to start right away, and they felt like it had not been adequately disclosed. So complicated gifts can highlight the importance that we work very hard in the Salvation Army, especially to explain the tax ramifications as best we can, and then encourage our donors to seek counsel for further explanation. But this, by the way, this flip trust was a case that we were aware about, but it got settled out of court. We've talked about the self-dealing rules that apply to charitable remainder trusts. So now let's move to the third model standard, and that's full disclosure, providing disclosure of all the appropriate tax and legal aspects of a gift. And this reminds me of that movie, Look Who's Talking, where, frankly, that baby in the movie with John Travolta and the other actors was highly, highly disclosed and quite a funny movie. So full disclosure, look who's talking. Anyway, when it comes to disclosure, a gift receipt is a very important piece of the disclosure process. IRS Publication 1771 lays out the requirements for gift receipts, the name of the charity, the date of the gift, the dollar value if it's a cash gift. If it's a non-cash gift, the law only requires charity to describe the non-cash gift. The charity does not have the duty to disclose on the gift receipt the value of any non-cash gift, stock, real estate, anything other than cash. All the charity is required to do is describe it. It's the duty of the donor and donor's appraiser to establish value of a gift. Also, though, the charity does have a duty to disclose the value of any goods or services received in exchange for a gift, like a fundraising dinner, the value of the meal, a fundraising golf outing, the value of the round of golf, etc. And if there are no goods and services, the charity has an affirmative obligation to put on the gift receipt the statement that no goods or services were received in exchange for the gift. Well, the IRS takes these rules very seriously. There are a number of rulings where upon audit, the IRS has found that charity violated one or more of the gift receipt rules. In this case, the Durden case, the charity failed to put on the gift receipt the statement, "No goods or services received in exchange for this gift." And because that statement was there, the deduction was denied. There was no question the gift was made, no question that the charity is legitimate. The simple problem of failure to do the gift receipt properly. Very important. Valuation of gifts is also, as I said, a burden on the donor. If a non-cash gift is triggering a deduction claim by the donor of $5,000 or more, the donor needs to secure a qualified independent appraisal, with one exception, publicly traded stock. So a gift of publicly traded stock of $1 million, no appraisal needed. But every other kind of non-cash gift, an appraisal if the value is over $5,000. A copy of the appraisal is not required to be filed with the tax return unless it's artwork over $20,000 or any other non-cash gift over $500,000. IRS Publication 561 is a very helpful publication explaining the valuation rules, determining the value of donated property, very helpful publication. The IRS Form 8283 is the form completed by the donor and signed by the donor, the appraiser, and the charity for gifts over $5,000. Now, charity is signing that form only attesting to receipt of the gift. Charity is not attesting to the value claimed. But if the charity does sell, trade, throw away, or otherwise dispose of the non-cash gift within 3 years for any gift valued over $500, the charity has to file the 8282 form disclosing the future sale, if that happened within 3 years. That's called the tattletale form. So the IRS is comparing the deduction claimed on the 8283 form with the resale value on the 8282 to see if there's a big discrepancy, and that might be a red flag for an audit. Here's a case where the donor did not get a qualified independent appraisal, and the entire deduction for an $18 million gift of real estate to a charitable remainder trust was denied simply because there was no appraisal taken. So fair market value, as I said before, depends on the method of delivery, or depends on the date of the gift, and the date of the gift depends on the method of delivery. So if it's a real estate gift, the date of gift is the deed of gift. If it's U.S. mailed, it's postmark date. If it's hand delivery, it's hand delivery date. And if it's a wired gift, it's the date it enters charity's account. I've already talked about the reduction rules for non-cash gifts, so I'm not going to go into detail other than to say that it helps charity to explain to donors in the receipt letter what reduction rule might apply to their gift. So I'm going to pass over those. There is a telemarketing rule. There's a Supreme Court case, the Madigan case, where the Supreme Court's position is that, let's say you have a telemarketer, and the telemarketer fee takes 80 cents of the donated dollar to pay for the marketing, and only 20 cents goes to charity. That is not fraud per se. That is allowable so long as, of course, that it's a prudently discerned contract that the charity board of directors has approved. And otherwise, it's perfectly fine. Now, it's fraud if the charity fundraising firm is asked how much is going to charity and they lie. Then you have fraud. But otherwise, the IRS has decided not to set parameters or dollar limits on how much has to go to charity and how much can remain in the hands of telemarketers or other third-party consultants or solicitors. There's also the concept of overhead. That is, how much money should charity assess to gifts to pay for its overhead? And as a few years ago, the 3 primary charity watchdogs issued a letter to all America's donors indicating that when you look at overhead, take into account all the factors. And some charities may need to spend 80 cents to get 20 cents. High overhead may be a necessity of some charities. When it comes to telemarketing, there are, of course, do not call lists. You're aware with that. There are rules in charities around charitable solicitation regulation. Charities who fundraise in other states may need to register to solicit there. Also, if there are for-profit consultants or third-party solicitors, they need to register in applicable states and sometimes file copies of their contracts. When With charitable gift annuities, there's a disclosure requirement. I'm not going to go into detail on that, but it was created as a byproduct of some lawsuits. And in the Salvation Army, we provide that disclosure. The disclosure for a gift annuity is to disclose the financial backing of the charity to offer the gift annuity. Compensation, Show Me the Money, the Jerry Maguire movie, great movie. And this is the case involving commissions. So in this case, investment brokers who recommended clients to do gift annuities with the National Community Foundation would get a kickback or commission. This was found to be a violation of ethical principles. This foundation essentially went out of business, but it was deemed to be an ethical problem. All sorts of other issues with regard to commissions for annuities. Fortunately, we're not aware of any now that are doing that. Here's an interesting Committee on Ethics decision out of Maryland where attorneys who chaired a church legacy committee and prepared wills on a pro bono basis were deemed to violate the state professional rules of conduct regarding conflict of interest when they were doing it for their own church. A very interesting case. I don't see a lot of these kinds of things. Instead, we have an Indiana case, for example, where the rules of professional conduct are not violated, where an attorney volunteers his time for a charity auction so long as the opportunity to create an independent consultation or attorney-client relationship is established. There is law that prohibits excess compensation to folks such as CEOs or board members who are in positions of control. United Way of America actually went to jail for skimming United Way money, and so the Internal Revenue Code Section 4958 prohibits excess benefits. Competence and professionalism, avoiding conflicts of interest. Here's a case from Indiana where a lawyer who served on both sides of a transaction. He was attorney. He was the CEO of a charity, and he also represented the hospital buying some property. And he was found to be violating conflict of interest, excessive fees, and he was ultimately disbarred. Here's a case from Indiana where a mother and father had left money and had wrote a legacy letter to the kids saying, Mom and I are going to pursue charitable interests with our remaining money and remaining years. And Dad died and Mom became incompetent. And this one son had power of attorney and decided to perpetuate Mom's charitable giving. The other son decided, why would you do that? Mom is incompetent and doesn't know what it's about anymore. And they came to loggerheads and a lawsuit, and the Indiana Court of Appeals sided with the son who wanted to perpetuate the philanthropy. And in fact, in this court ruling, they quoted at length from the legacy letter that Mom and Dad gave their kids, articulating their intent for philanthropy for the rest of their lives. So it's a very interesting case. Consultation with advisors. We do promote this consultation all the time. This is a wonderful 5-minute NPR story you can listen to. Richard Leroy Walters, homeless, left in a state of $2 million, and a fascinating case. Obviously, he didn't have any legal counsel, but he left a large gift to multiple charities. Charities have to be careful what role they play. They're sometimes asked to be personal representative, trustee of trust. Generally, we have to be very careful to cross boundaries and not be personal representative of the state. We will, in the Salvation Army, serve as trustee of charitable trust under certain conditions, but we always want to recommend independent counsel to our donors. Generally, my advice is that the parties whose interest is being protected is the party who pays the appropriate fee. So I think in the case of gifts, the donor pays for their own legal and accounting fees, of course. The donor pays for their own independent qualified appraisals. The charity may pay for the cost of title, transfer, insurance, or environmental review to protect charity's interests, or these costs can be paid for out of the cash proceeds of the gift, which is a nice way to structure those. We encourage you as professional advisors to consult with us as charities, especially if your donors want to restrict gifts. You might ask our advice on whether gift restrictions or other aspects your client is working on will be copacetic and what's the best way to handle it. So We try to document our discussions. We always try to recommend independent counsel. We do provide sample documents, but always with the provision that they show them to their independent counsel. We had the Woodrow Wilson case where the family, the Robertson family, sued Princeton over not adhering to mom and dad's original intent for the gift. $40 million in legal fees paid. It ended up with a settlement where basically the money was left with the Woodrow Wilson School with a carve-out for a private foundation separate from that. But even a book has been written about that by Doug White. It's a very interesting story. Most charities have gift acceptance policies and procedures that require adherence to ethical principles as well as best practices for completion of gifts. Charities that accept pledges book them pursuant to FASB accounting standards. Generally, that means at some level they might be legally enforceable. Very rarely do charities sue to enforce these pledges, but they are bookable as a receivable pursuant to FASB standards. There are a variety of legal principles under state law that have been used to enforce pledges. The description of a gift is very important to be accurate and truthful. There's the movie The Usual Suspect, where it was very unclear who the criminal was in that case, and so we want gifts to be as clearly articulated as possible. I've already talked about endowments, so gift agreements for endowments have to be very clearly stated. The policies that govern endowments should be clearly articulated so there's no confusion or surprise. Endowment agreements have to include a lot of key items of information. You can talk to our plan giving staff at the Army to see our sample endowment agreements. Full compliance with all applicable laws and ethical principles. This is the second to last of the model standards. And I love that movie, Oh Brother, Where Art Thou? The criminals are up in the barn and the fire is raging, and one of them, George Clooney character, says, "Ooh my, we're in a tight spot." And oftentimes when charities get into bad gifts, you see that. I'm aware of many instances where folks were on audit found to be skimming charity gaming proceeds, like bingo, pull tabs, and so forth. These are highly regulated at the state level, and you have to be very careful with charity gaming. The IRS every year issues a Dirty Dozen list, which usually includes abuse of charitable organizations. We had the case of the Feeding Our Future fraud scheme in Minneapolis this year, a $250 million scam involving federal money. This is the inappropriate use of charitable organizations, one of the Dirty Dozen lists from the IRS. There's the issue of legal standing I talked about earlier. There are cases where donors have been found to have standing. Here's an example of one. But in many cases, standing not allowed. Rather, the expectation is the Attorney General should be the party seeking either a cure to misuse of a gift or a cure to a charity inappropriate behavior. We have, in many states, the Attorney General role is defined under the Trust Code, but there are many cases, such as this one in Indiana, that expanded the authority of the Attorney General and oversight of gifts and charities, not just to charitable trusts, but also to nonprofit corporations. Many states have given the Attorney General broad injunctive relief and other powers. We have had cases in Indiana, and I know I'm aware of others in other states, where these injunctive powers to appoint trustees, to freeze assets, are very helpful to avoid abuse. There is in the Uniform Law Commission Protecting Charitable Assets model law, where again it talks about expanding the role of the Attorney General in protection of charitable assets. Some bad gifts, good gifts gone bad. Life insurance. We had the case of the charitable reverse split dollar life insurance that went all the way to the U.S. Supreme Court, where it was found to be an inappropriate. We had in the split dollar life insurance, both the donor and donor's family and charity were both co-owners and co-beneficiaries. And basically the law says that's an inappropriate partial interest. It's not one of the qualified partial interest gifts. We had a charitable Maynard trust with huge payout rates and a small number of years, like 20 to 50% payout rate and 2 to 4 years to pay it out. So it washed all the capital gains tax, left very little for charity at the end. This was also called the Full Monty or Chutzpah CRUT. This kind of crud actually was outlawed when Congress passed the 10% minimum deduction rule. The 10% minimum deduction rule says that when a charitable remainder trust or a gift annuity actually is set up, then when you calculate the present value of the remainder interest, that has to be at least 10% of that remainder. So if you give $100,000 for a charitable remainder trust, then the charitable deduction present value amount has to be at least $10,000 or 10% of the $100,000. There also was the ER or Gulclat. I guess we're in the Halloween theme here, where with a charitable lead trust, you might have a life interest used as the measuring life for zeroing out, let's say, the clat. But the problem is, that person has a shorter than normal life expectancy, and that the family will end up with the money in a year or two because of that known medical problem. And so this issue was addressed by Treasury Decision 8923 to prevent the use of a measuring life where a knowing medical problem exists. The final kind of topic for the model standards is public trust. That model standard states, and I like to read this one, gift planners shall, in all dealings with donors, institutions, and other professionals, act with fairness, honesty, integrity, and openness. Except for compensation received for services, the terms of which has been disclosed to the donor, they shall have no vested interest that could result in personal gain. And my movie reference for this one, of course, is It's a Wonderful Life. These kinds of gifts that help philanthropy and do the most good help us live certainly a wonderful life. And there are some great resources I like to talk about in this regard. One resource is the ethical will for preparing heirs. That is a type of legacy statement. Statements of personal values, aspiration, wishes, executed in addition to legal documents. And there's some great resources for this kind of documentation, the National Center for Family Philanthropy, the Institute for Preparing Heirs. In fact, it was exactly this kind of document that in the Miller case that I talked about earlier, where mom and dad, while they were still competent, wrote a letter, gave it to the kids saying, we lived a good life, we've supported you, put you through college, whatever. Now we're going to turn our attention to philanthropy, and these are our intents and our wishes, and we want you to respect that. And in that case, as I indicated, dad had died, and then mom was incompetent, and one of the surviving sons said, well, look, mom isn't competent anymore, so let's just not give any more to charity while she's alive, but just save it for her needs, and then the kids will have more when she dies. And the other son didn't want to do that. He thought that mom and dad had expressed this intent through this ethical will or legacy statement, and that they should fulfill it. It's not legally binding on them, but that's what they thought they ought to do. Now, so it went all the way to the court. Now, interestingly, he had power of attorney control, but the power of attorney document in that case did not stipulate power relative to gifts, but it was broadly enough stated, or the court felt that the power of attorney language under the code gave enough discretion to allow this to happen. But in your preparation of power of attorney documents, you could reference charitable giving, you could reference these ethical will statements and so forth to allow those with power of attorney authority to say perpetuate philanthropic giving of those that they are managing assets on behalf of. Of course, terrorism protection has become a prominent aspect of our work ever since 9/11. Charities that are involved in, say, grant making or accepting gifts have to make sure that those grants or gifts are not directed or used in any way by terrorist activity. There are ways to conduct what's called expenditure responsibility. GuideStar and other services, as well as the Treasury Department website, offers helpful guideposts and ways to track and prevent terrorism-related activity. Look, at the end of the day, for most nonprofits, it begins with good governance. The Salvation Army for 100 years has proven itself time and again as well managed and governed well to earn the trust of our benefactors and the broader community. So governance is exceptionally important. And so many of you on this call I know are on boards of directors or you're counsel to nonprofit organizations. And I encourage you to take a look at the independent sector website. They have a model code of ethics, so a nonprofit can establish a code of ethics governing the activities of the nonprofit. Also, it has a workbook highlighting 33 principles of good governance that a nonprofit board could go through and make sure they're complying with these good governance. One set of rules apply to responsible fundraising. Another set of the 33 principles apply to financial management. Another that applies to governance, and the fourth to legal oversight and legal establishment of the nonprofit. Wonderful resource. Can't recommend it highly enough. And at the end of the day, I would say good ethics, good nonprofit management starts and ends with good governance and good management of the nonprofit by the board at the end of the day, as well as, of course, staff. The Internal Revenue Service has done an amazing job, in my opinion, of trying to robustly provide a plethora of good resources at its website that I encourage you to take a look at. You can just Google in tax-exempt organizations and get into these materials. This is just a small list of the kinds of things, publications that are available to help guide you through issues. So, for example, with churches and religious organizations, publication 1828, that talks about issues relative to payroll tax, issues around avoiding any political campaign activity. You know, nonprofits, including churches, cannot engage in any political campaign. 501c3s risk the loss of their 501c3 status by engaging in any political campaign activity. Now, 501c4s can engage in political activity, but not 501c3s. And by that I mean public charity 501c3s and private foundation 501c3s. They can't spend a dime or be involved in political campaign at all. And as far as lobbying, they can only do a limited amount of lobbying and limited or insubstantial amount of lobbying. And if they want a bright line dollar amount for that insubstantial amount, they can take the 501h election. And some charities set up a separate 501c4 for that kind of lobbying, more substantial lobbying. But the tax guide on lobbying and political campaigning are at their IRS website, as is the helpful guide for churches. The 5221 helpful for C3 organizations, and the 4221 NC for non-C3. And then if you're a veterans organization, another helpful publication. I already referenced publication 526, charitable contributions, 561, determining the value of donated property. All sorts of marvelous resources available for your use. So as we wrap up our hour of talking about the ethical considerations, the question for all of you on this call is, are you able to fairly comply with all ethical and legal standards for estate and charitable planning? Because always remember, in the words of one of the most famous movies and the most famous movie heroines of all time from Gone with the Wind, tomorrow is another day. And so with that, I want to thank all of you for your time and attention today. We have a few questions that we can respond to, and we do encourage you to type your questions in. We do want you to get your credits for today's program. Be sure you fill out the attendance form that your staff or volunteers at your site have for you. Those of you who are participating virtually, we have a record of your attendance as long as you kept clicking that you are here during the virtual presentation. But again, we can't thank you enough for your time and attention today, and we hope that we can be of assistance to you to help fulfill the needs of your clients. Thank you. So now we move into questions and answers, and don't have a lot of questions here. I know it is end of the day. One question was, can an heir to an estate avoid paying income tax on an IRA by disclaiming the IRA to charity by filing a disclaimer? That would be problematic. We'd have to do a little research to see if there are any rulings. The rulings I shared with you today had to deal with the executor or personal rep trying to satisfy charitable intent by selecting these assets. But in those cases, they didn't have an otherwise designated heir to the IRA. And so the disclaiming might not meet with favor with the IRS and might not be successful. I'm not aware of a more recent ruling that would allow that. But for any of these charitable related questions, anybody on this call is certainly welcome to contact your local plan giving staff member or me directly. And I'm always willing to take a closer look at any of your issues more directly. Another question had to do with the remainder interest of a farm and whether a tree farm, walnut trees or other harvesting of trees, would qualify as a farm. I'm not aware of a private letter ruling or other ruling that defines farm in that sense. Of course, with the remainder interest, you've got to have. I don't know by the nature of your question whether the tree farm is in fact it's just something they harvest now and again, or it's a regular farming operation. So a little more facts might help on that one. If it were a farm, and the question would be, could the life estate owner have additional rights like mining interest rights or tree harvesting rights? That would be possible to have for the life estate holder. That's for sure. Another question concerning the liquidation of personal property valued in excess. I work with a library friends group where we regularly sell donated books. Some donations are so large they exceed the $500 limit. Does a charity group need to file the form you mentioned with the IRS? Well, if the gift and it applies to an individual item or a group of similar items, these rules apply to. If the donor claimed a deduction, filing the 8283, what you worry about is when you later sell, and it's over the $500 limit, how does that subsequent sale price compare to the earlier deduction? Now, it says on the 8282 form to share a copy of that form with the donor. What I like to do is let the donor know that we're getting ready to sell it, here's what the price looks like, and to give them a heads up if there might be a problem on audit. And so the answer would be yes to your question. The 8282 form would be required for any donated gift over $500 where you later sell it. And again, there's a 3-year time frame there. It's as long as the sale or disposition happened within 3 years of the gift, that triggers the 8282 form qualification. And that's the only other question I see on here. It looks like, but if there are any other questions at any time that anybody has, feel free to email me directly. phil.purcell@usc.salvationarmy.org, phil.purcell@usc.salvationarmy.org. Happy to answer more questions if you have them. And I encourage you very much to seek the answers from your local plan giving staff as well. And if they have questions that they can't answer, they'll come to me too for assistance. I did see another question pop up. In donations of remainder interest in vacation home, kids want to buy remainder interest. So it is possible for the charity to sell its remainder interest to the kids or any other party. It would have to be done for fair market value. You'd have to worry about an excess private benefit if you didn't sell for fair market value. So you'd have to definitely get a new appraisal of the property and value that remainder interest, but it would be possible to sell it. So that's the final question I see. So I don't see any other questions on the board, and you have a plethora of information here, the PowerPoint slides, the extra handout. Hopefully they'll be helpful to you in your practices, and we're always available at any time. Again, on behalf of the Central Territory, I want to thank all the staff, all the volunteers, the host sites and the sponsors that help make today possible. Sincerely appreciate all the hard work to make this happen. And we want to thank all of you professional advisors for being with us today and making it a part of your day so that you can learn to be of greater service to your clients, both with their estate and charitable gift planning. So with that, I will end the program and wish you all good graces and God bless. Thank you very much.